Work in Canada is changing fast. The past 2 decades have experienced a decline in full-time, permanent jobs with guaranteed benefits. Precarious work with limited contracts and low wages has grown twice as fast as standard forms of employment. Racialized women experience the highest rates of precarious work.
The changes to Canada's labour market are a big problem. Many people work multiple, insecure jobs with long, exhausting hours.
Despite this current work climate, labor laws are changing and workers still have rights.
Whether you are currently employed or searching for work, the Ontario Human Rights Code states that every person is free from employment discrimination on the basis of race, ancestry, ethnicity, or place of origin. This information can be found at.
Here are the recent changes to Ontario employee rights. Temporary agency workers are no longer protected by equal pay provisions, meaning employers can still pay a temporary agency worker less than what a permanent staff member would make in the same role. Leave days have been reduced to 3 personal sick days, 2 bereavement days, 3 family responsibility days, which are all unpaid. Employees are entitled to 3 hours pay for shifts that are under 3 hours. However, they no longer have to be compensated for being on call or if their shift is canceled with less than 2 days' notice.
If you are not unionized but believe your employer is violating the Ontario employment standards, you have the right to file a claim with the Ministry of Labour online through their website.
Employers are not allowed to penalize, intimidate, or fire employees for asking the employer to comply with the Employment Standards Act and its regulations, asking questions about rights under the ESA, filing a complaint under the ESA, exercising or trying to exercise a right under the ESA, giving information to an employment standards officer, taking, planning on taking, being eligible, or becoming eligible for a leave.
Temporary agency workers have the same rights as other workers. The temporary agency is your official employer. The place where you work every day is called the client company. Both have legal responsibilities for your work.
The Workers' Action Centre has put out resources for temporary help agency workers to remember. The temporary agency and the client company are responsible for providing safe working conditions. If you do get hurt, report it right away. It is illegal for your boss to tell you to not report a workplace injury or illness to the WSIB. If the temporary agency does not pay your wages, then the client company is responsible for the money you are owed. If you are fired or laid off by the agency, you should get termination pay or notice.
A temporary agency cannot charge you a fee for signing up with them. Even if you are paid in cash, you must still be paid the minimum wage and be given a pay slip. Neither the temporary agency nor client company can penalize you for asking about your rights.
You have the right to refuse unsafe work. You are entitled to public holiday pay and vacation pay. You are entitled to vacation time after your first year of work, paid by the temporary agency. Temporary agencies cannot prevent a client business from giving you a job reference, hiring you directly, or tell you that you cannot take the job.
With the growth of precarious work, there are misconceptions around who is classified as an employee versus independent contractor. An individual may be considered an employee even if the individual and the business agree orally or in writing that the individual is an independent contractor. It is the relationship between the individual and the business or person that matters, not the label that is given to it.
You deserve to know your rights. For more information, check out these resources.